And I'd like to appreciate getting the opportunity to speak on this bill here today. The Workplace Relations Miscellaneous Bill 2021 proposes to amend the Workplace Relations Act 2015 and Unfair Dismissals Act 1977 in response to the judgment of the Supreme Court in the Zalewiski versus Adjudication Officers. The Court upheld the constitutionality of the WRC's adjudication services, but held that S 4113 of the 2015 Act and S 86 of the 1977 Act were incompatible with the Constitution. These sections require relevant WRC proceedings to be conducted private. Additionally, it was held that the lack of legislative provision concerning the administration of oaths or affirmation of providing for a penalty for giving untruthful evidence was inconsistent with the Constitution. The bill proposed to amend the 2015-1977 Acts to provide that evidence may be given under oath and that a penalty may be enforced for the provision while under oath of false or misleading information, and that matters before the WRC adjudication services will be conducted in public to save in certain circumstances. Similar amendments will also need to be made to the Employment Equality Act 1998 and the Equal Status Act 2000. In addition to these constitutionally required amendments, it is proposed that the following amendments be made to address further issues raised in the majority judgment of Supreme Courts: amending the 2015 Act to provide for a fairer system for the removal of the WRC adjudication officer, amending the Industrial Relations Act of 1946 and 1969 to provide an express statement that the chairperson and the deputy chairs and the ordinary members of the Labour Court are independent in the performance of their duties, amended the 2015 Act to strengthen the rights of employers in matters relating to the enforcement of decision of an adjudication officer in the District Court. The Supreme Court ruled on the 6th of April 2021 that systems operated by the Workplace Relations Commissions and the Labour Court to determine employment claims and disputes is not unconstitutional. The law that was challenged was Part V of the Workplace Relations Act 2015. The challenge was based on the argument that the system involved the administration of justice, whilst the Constitution provided this could only be done by courts and judges pursuant to the Article 34, which states Article 34 does state that the justice shall be administered in courts established by law by judges appointed in the manner provided by this Constitution, and save in such special and limited cases as may be prescribed by law shall be administered in public. The Supreme Court decided that the WRC was only exercising limited jurisdiction, something which is permitted by Article 37. And Article 37, nothing in this Constitution shall operate to invalidate the exercise of limited functions and the powers of a judicial nature in a matter other than criminal matters by any person or body of persons duly authorised by law to exercise such functions and powers, notwithstanding that such person of such body of persons is not a judge or a high court appointed to or established as such under the Constitution. However, the Supreme Court did observe that justified questions were raised as to the procedures which the WRC employed, including evidence being given without the taking of an oath, the absence of a right to cross-examine a person giving evidence, and was hearings not being held in public. The WRC does permit cross-examination, and the failure of the legislation to make express provisions for it did not render the legislation unconstitutional. However, the Supreme Court did declare A. Evidence being given without an oath or affirmation and no penalty for untruthful evidence, and B. The removal of the possibility of certain cases being held in public by virtue of Section 14.3 of the Workplace Relations Act 2015 and Section 8.6 of the Unfair Dismissals Act 1977 are inconsistent with the Constitution. The High Court had previously ruled that the WRC was not administering justice, as any decision must be brought to the district courts to be enforced if the losing party did not abide by the determination. And I suppose that kind of sums up to the situation we're in now. We certainly, every TD here in the country should fully support the WRC and the works it's carrying out, and if it needs an increased powers, by all means we certainly would be in agreement with that. The Rural Independent Group, I suppose most of us are employing people, and we have to abide by the rules and the regulation that's out there. A lot of people, enter into disputes, unfortunate disputes, whether that's in, it could be in a healthcare situation, it could be in any situation, it could be even in the community voluntary sector, where a lot of employees could be working. And most of these disputes, unfortunately, if they're not nipped in the bud, they get out of control and they end up in the, unfortunately, in the situation that they end up with the WRC. And it's an unfortunate situation, because sometimes when you're in that situation, it's very hard. There's no winner there. As such, the employer or the person taking the case is going to, feel that they're under severe pressure that took them to that. That brought them to the situation that they're in, that they had to take their case to the WRC, and a judgment will be made, whether they're right or wrong. But I do sympathise with people, but I am a strong believer that stronger negotiations should take place between the parties before it gets to that point, and if at all possible, and if there's a good negotiator in your team where you're working, or your voluntary sector, they should be put to work to try and nip something in the bud. And if that's not done, unfortunately, it leads to a very dangerous situation. And a lot of decisions are made here in Parliament, and it leads to very difficult decisions having to be made on the ground with people. And during the week, we spoke about the hospitality sector, and where bars and restaurants are now facing closure for God only knows how long ahead, and if they do open, they'll have either the employee or the person who's running the business must stand at the door and must ask everybody that's entering, have you been vaccinated, haven't you been vaccinated? The pressure that's going to put on employers and employees, it's phenomenal. And the restaurant owners and the publicans are saying they're not going to work this. So I don't know who's going to work this. Is a daft idea, because, with a situation with young people not vaccinated, you're going to have a situation where some people can genuinely get in because they can't get a vaccination, and you have an employer trying to get a staff member to carry out that role, which is in its own right probably against their own wills, and it makes it very difficult. So decisions we make here actually can have a bearing on what happens on the ground, and the difficulties between employers and employees. And I look at the fishing sector, in recent months, the difficulties that was hoisted on them from every angle. Without anyone here saying pull up the handbrakes in government and stop a minute. There was obviously no senior minister, regardless of what we tried to try and start. The penalty point system was hoisted on their back, the weighing crisis was hoisted on their back, and there was no one here. And then down in the convention centre, in one of the sessions we had, in the very few times we could talk about the fishing industry, we had a member of the People Before Profit come in and say that the fishing industry have foreign workers treating them appallingly. That's an awful statement to make, and I'm shocked that he hasn't come in here and apologised to the Dáil for his statement. If that's the way the People Before Profit think about the fishing industry, and they're working hard, and they're spending months and months and months with me around the table and on phone calls trying to protect the foreign workers that are working on their fleet. That's what they were telling me.
Passion for these issues, but you'll have to admit you're wandering a bit away from the provisions of the bill.
Sure, I suppose it wouldn't be the first time I wandered a bit, but you might bear my indulgence, because I was angered greatly at the People Before Profit to make that statement and haven't yet come back here, because I wouldn't mind, and it is in relation to workers' rights and workers being treated wrong, but as I said, I don't mind. We'll all say something in here. We might have to come back and make some bit of an apology, and I would certainly if I said something wrong, but it was very wrong to do that. And as I said, I was talking to individual owners of trawlers. I was talking to the fishing sector, Irish Southwest, who had contacted me, Patrick Murphy, to try and rectify that situation, the wrongs that have been done to the foreign workers on their fishing vessels. And then I hear a complete opposite statement, as if to the fishermen and the owners of the trawlers are carrying out these wrongs, which is totally untrue and unfair. And look, I'm not going to take up all of my time, because I might wander a bit more, but I definitely will be supporting this going forward, and any laws that will strengthen the right of the worker in a very fair way. But we must also always remember one thing: the employer You know, when we're picking at anyone, we're always picking at the employer. We're always picking at and they can't take much more pressure because they're under a severe amount of pressure with payments and, you know, whatever, you know, being as fair to workers as they humanly possibly can. So we have to find a very fair balance here, and I appreciate, Minister, and your government, that we'd work together to find that. And amendments, obviously, we've put forward to try and see can they be a fair balance found in this. Thank you.